the Speaker will be called upon on Tuesday to declare 4 parliamentary seats vacant and declare them as lacking constitutional recognition.
Well, tonight, the majority leader in last-ditch attempt to block effort to unseat 3 of his majority colleagues as he files action at the Supreme Court to stay hands of Parliament on the matter. But Parliament is engaging in a heated debate on the matter.
In the case of the second Deputy Speaker, that he has decided to join the New Patriotic Party, or let me say, rejoin the New Patriotic Party, because he came into Parliament initially as a member of that party, went independent, but then he has decided to join the New Patriotic Party. And in the language of the Constitution, when he makes that decision, he shall vacate his seat.
We're in Parliament where the action is happening live. We'll bring you all the updates on this particular matter. This is Top Story brought to you by Telecel, connecting energies and holding insecticide spray and coil. Well, the majority leader, Alexander Feomake, is making last-ditch attempt to block moves to unseat 3 of his colleagues and end the side's reign as the majority in Parliament. Former Minority Leader Haruna Idrisu has formally kick-started processes to have 4 seats in Parliament declared vacant, 3 on the majority side and 1 on the minority side. 3 of the affected MPs have ditched their political parties to contest as independent, whilst 1 other, an independent MP, is running on the ticket of the NPP. Let's take you to Parliament now, where my colleague Kweku Asante is joining us live. Kweku, so what has been happening in Parliament?
Well, so earlier, like you said, in a bid to preempt whatever Parliament was going to do, the majority leader, Alexander Feomake, did file an action at the Supreme Court. He claims that document has duly been served on Parliament. We haven't seen copies of that yet, and so he wanted to stay the hands of Parliament. Throughout the day, it appeared Parliament wasn't going to act on this until the minority leader, in a move to overreach the former minority leader, did raise this issue using the standing orders by way of an urgent statement. And so he did make an urgent statement on the floor, inviting the Speaker of Parliament, Alban Bagbin, to make a determination that upon looking at the facts of the case, it is obvious that those 4 persons have vacated their seats, and their seats should consequently be declared vacant, so that ultimately the minority will become majority. The majority, as currently constituted, will become the minority. And he has raised those issues, and the majority leader, Feomake, has officially informed Parliament that he has also filed an action in this matter, and he does not want Parliament to continue. But in any case, he believes that the minority case is simply not well made. We have heard from former Deputy Attorney General in the person of Dr. Dominic Kayene. Currently on the floor speaking is the former Attorney General and the former President, John Ajay-Kunkufo, also one time a Deputy Speaker of Parliament, Joe Gatti, making submissions forcefully that Parliament is simply not properly constituted to discuss these matters. It says it is not in the purview of Parliament as presently constituted to be discussing these matters. We expect that these debates is going to go on and on. The Speaker of Parliament has already hinted that after the debate and comment, if he is minded to make a determination, he will do so. If he wishes to also go ahead and write a full ruling and bring it to the House on a subsequent day, he will do so. So we can cross over now to the floor of Parliament, where Joe Gatti is making a forceful debate that Parliament cannot do this, and we expect that other members are going to weigh in, and then the Speaker of Parliament ultimately, at the end of this, will make a determination.
A member of the party, that member has a right to be heard. That member has a right to be heard. And indeed, Mr. Speaker, it says in Article 55(5) that the internal organization of a political party shall conform to democratic principles, and its actions and purposes shall not contravene or be inconsistent with this constitution or any other law. The New Patriotic Party has not announced to anybody that the 2 members of Parliament are no longer members of its party. Neither has the New Patriotic Party told anybody that Honorable Esiama's situation has changed. Mr. Speaker, these are matters of deep interpretation. These are matters which lies strictly in the bosom of another forum. The forum has been told me by my friend Honorable Abuja. He has directed me where to go. He has pointed his hands that it lies in the bosom of the Supreme Court. The danger, Mr. Speaker, the danger, my colleagues and friends, is that if we are not careful, we will embark on a course of action that will seem to take the powers of one arm of government and exercise it in this forum. In fact, our standing orders keep on saying that if a matter is before court, we should keep it before court. Indeed, what Honorable Dominic Ayeni said about the Supreme Court saying that it does not give advisory opinions and so on and so forth, these are matters that will be argued there. With the greatest respect to Honorable Dominic Ayeni, I have a lot of respect for him. He teaches law, I also teach law. He's not only teaching law in the house. Yes, he teaches law, I also teach law. And I started teaching law before him in 1992. And I've taught law longer than him. So, with the greatest respect to Honorable Dominic Ayeni, my revered colleague, not just in Parliament, but also in the academic arena, these are matters that me and you know that are best suited to be answered by the Supreme Court. I am not saying for a second that Mr. Speaker is not competent to answer these questions in his own capacity. Mr. Speaker could have been the Chief Justice or could have been the Supreme Court. If he was in that forum, I am sure we will all hear his views. In this forum, I tell Mr. Speaker that the distance seemed one step enough for him. Or the 93.6 states what he can do in this circular. It says, and I end by that quotation, where a member makes a statement, the Speaker, considering the comments of the statement, may direct a committee to investigate and inquire into the matter. The Speaker, respectfully, in these circumstances, cannot rule. Thank you very much, Mr. Speaker.
Yes, Honorable, is it Mama Yalaga? Yes.
Thank you very much, Mr. Speaker. Mr. Speaker, I think that we are dealing with very straightforward matters. I say very straightforward matters because Order 18 of our rules state clearly that the Speaker shall inform the House of the occurrence of a vacancy of the seat of a member under Clause 1B to E, G, and H of Article 97 of the Constitution. So, Mr. Speaker, strictly speaking, it is your province to declare the vacancy of a seat. It is your province. And you could act whether you are informed as such by a political party or because the matter has come to your attention as a matter of fact. It is your province. So, Mr. Speaker, what has just happened today is an attempt by a member of this House to bring to your notice certain factual matters, which matters establish that some members who came to this house on the ticket of political parties have gone to file as independent candidates to contest the next elections. And another member who came to this house as an independent member of parliament has gone to join a political party, because unless he joins the political party, he cannot contest on the ticket of that political party. So he's going to join a political party and has filed on the ticket of that political party. This is also a matter of fact. Mr. Speaker, all those who have spoken so far have not disputed these facts. They have not disputed these facts. And in fact, the Electoral Commission, I believe, has issued notice of polls, and these facts have become public. So, the issue is the minority leader, who I believe by this time should properly be addressed as the majority leader, is seeking to bring to your attention these facts as matters of urgent public importance. The question is it a matter of urgent public importance? Mr. Speaker, go to the interpretation provisions of our standing orders. And it says that minority caucus means the members of the party or parties that have the second largest number of seats in the House. It also says that majority caucus means the members of the party or parties that have the largest number of seats in the House. Why am I referring to these two provisions? Because if you do exercise your powers under Order 18 and confirm the vacancy of these 4 seats, a matter of urgent public importance will occur immediately, because the constitution of this very House will change. The balance of power will change instantaneously, because this side will cease to be the majority side, and this side will also cease to be the minority side, and this side will immediately become the majority side, and that side will become the minority side. This is why it is a matter of urgent public importance that the public should be aware of. So the question is whether or not it should be by a statement under Order 93 or by petition. Mr. Speaker, I think that if a petition brings the matter to your attention and you decide to act, fine. But also a statement under Order 93 can bring the matter to your attention so that you can exercise your responsibilities and powers under Order 18 of our standing orders. Mr. Speaker, I believe also that the question of the substance, because what I've said so far deals with the procedure, the question of the substance is also not disputed. Because if you read the two provisions, they are clear. But the majority leader, who I believe will soon be the minority leader, has stated that he has gone to court. I believe he's gone to court because he thinks there's something there that requires the consideration of the Supreme Court. That's up to him. But this House is governed by its rules. And the Constitution is clear that we are governed by our rules. And you and whoever sits there as Speaker interprets the rules. And the rules have been interpreted before and enforced in this House. And the position is that when a sitting member of Parliament, sitting here as a member of Parliament on the ticket of a political party, during the term of Parliament, decides to file nominations to contest as an independent candidate, this House, through a previous speaker, has ruled that that person ceases to be a member of parliament. The seat becomes vacant. That is the rule we have. What the Supreme Court will say tomorrow based on his, application there is a matter that tomorrow we'll wait and hear. But for now, Mr. Speaker, as we sit, the rule is that when you go and file as an independent member, to contest as an independent member, or vice versa, you cease to be a member of parliament. That is the rule as we have now. You may agree with it, I may disagree with it. We may have our disagreements, and my disagreement with the rule is a matter of public knowledge. But whether I disagree with it or not, as we speak, that is the rule. And the rule benefited the MPP yesterday. And it should benefit the MPP today. I don't know why he is challenging. I don't know why he is agitated about it. I don't know why he ran to the Supreme Court even before Parliament resumed. But the rule is clear, Mr. Speaker, that if you are a sitting member of Parliament on the ticket of a political party, and when nominations are open, and you go and you don't file on the ticket of your party, and you go and file on the ticket of, as an independent, Mr. Speaker, this House, based on the ruling of your predecessor, did the seat vacant. The same way, vice versa. If you come here as an independent candidate, a member of Parliament, and during the pendency of this Parliament, you go and join a political party, and you file to contest on the ticket of that political party, Mr. Speaker, the rule equally applies to you, and you cease to be a member of Parliament. Mr. Speaker, this is a simple matter. Like you have rightly noted, these are comments we are all making. It is for you to take a decision, whether or not you need even to think about it any further, whether you want to, guide us today and determine what the proper position is. But we are only drawing your attention to these facts, and also further draw your attention to existing precedent and the rules, and also draw your attention to the provisions of the Constitution. Thank you very much, Mr. Speaker.
Yes, Honorable Atachia.
Yes. Thank you, Honorable Speaker. I'm so saddened by what is happening in this chamber that I'm tempted to bring to the attention of Honorable Speaker of the Lord's Prayer. In the Lord's Prayer, Jesus said, "Lead us not into temptation, but deliver us from evil." Oh, that is a very serious statement. Today, I'm hearing for the first time that if you want to have majority in Parliament, you go to the December pools, but they are going to use your energies and your talent so they become the majority. That's pathetic. That is very pathetic. If you want to win and be majority, December is staring at you in your face. Why do you want to have the speaker with this kind of program? I don't understand it. I don't understand. You are running away from December 7th and you think that the speaker should aid you so you become the majority. Oh, this is pathetic. It will happen today, it will happen tomorrow. Honorable Speaker, let me ask something very important. Yes, it will happen today. It will, Mr. Speaker, to become a majority. That's what I'm saying. You can't use the speaker to win elections. You should stop what you are doing. Honorable Speaker, let me come to very important matters. I didn't know that the majority leader has taken out a suit in the Supreme Court. And in the suit, with the greatest of respect, the Right Honorable Speaker is joined as a party. And there is also an injunction against Honorable Speaker. Do you want him to be committed for contempt? If you should go ahead with this matter, is that what you want to do? Do you understand the full implications of somebody calling the speaker before the Supreme Court and you saying there is an injunction and the speaker should defy the injunction, so he's cited for contempt? What kind of indignities are you inviting the speaker to be involved? What is the meaning of this? I don't get it. This is what you are attempting to do. So right now, Mr. Speaker, on the strength of the plaint before the Supreme Court and the injunction, whatever minority leader is trying to do via my vulnerable friend, the former minority leader, has been checkmated. Look, it has been checkmated by the application for injunction. I didn't tell you about the full implications of MOFAT, that when an application is pending before a court and you go contrary to the purpose and the intent of that application, you are in contempt. So I don't know why you are so excited about the fact that, you want to push Honorable Speaker to proclaim a declaration so you become a majority. Now let me show you something which is very important. The import of making a statement. When you make a statement, and 93 says, you see, when you make a romancing statement like this one, it is not automatic that Honorable Speaker will do your bidding. This romancing thing you did here, you read the order properly. 93:6, where a member makes a statement, the Speaker, considering the comments on the statement, including we informing him that there's an injunction before the Supreme Court, we have told him, may direct, he may. The Speaker is not a conveyor belt for you. He may not. Direct a committee to investigate the matter and inquire into the matter when necessary. So, Mr. Speaker, this is a particular time that you shouldn't not even look at it. That I respect the trinity of governance. The trinity of governance is that we have the executive, we have the legislature, and we have the judiciary. We don't need a collusion cause for Honorable Speaker to say there's a plaint at the instance of majority leader and there's an interlocutory injunction to boot. Nevertheless, I will rubbish another arm of government for the sake of the pleasure of somebody who is running away from the polls and believes that this is the forum for him to become majority. So that's why I quoted the scripture that they want to lead you to temptation. Resist this temptation. I have come the entire scheme, which is the Quran of parliamentary practice in the Commonwealth. I have never found a statement in scheme which will make a speaker an extension of the Supreme Court. This is what you are attempting to do. You see, what you want the speaker to do is to interpret the Constitution. That is not his remit at all. And I've heard very jejune arguments that the errors of yesterday, if somebody made a mistake as a speaker, this honorable speaker should repeat it. You understand? The speaker is not a rubber stamp to come and repeat matters of yesterday, and he can't do his own thinking and distinguish the circumstances, the difference between the situations. This is what we're attempting to do. You quoted the president. Today, have you seen the members of MPP crossing carpet? Have you seen it? Who has crossed carpet? And Honorable Speaker, what is a pain for me? That today they want you to determine what these members of parliament want to do in the future. That is pathetic. Do you know what they want to do? What if they change their minds? So why are you dealing with the future when the now situation is that they've not crossed carpet? How can you pray in Article 97 when the individuals have not crossed carpet? There's no factual basis to support the conclusion that they've crossed carpet. Now you inviting this hallowed chamber to consider the pleasures and the wishes of some members of parliament, thinking about post December 7 and what they want to do. Do you think we play lottery in this house? We don't play lottery like that. We don't do that. So, right now, Mr. Speaker, let me bring to the attention of this House that there's a very dangerous precedent former minority leader attempted to do. And I'm very sad that these lawyers are clever and they want to bring the Choboy arguments into this hollow chamber. These things you can say it when you're on the platform. But let me show you what the Constitution says. Very, very interesting. Honorable Speaker, the governance system of this country are properly demarcated in the Constitution. There is no way one arm of government will usurp the power of another arm of government. So let me read for your consumption Article 130. Subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive, not a co-terminal jurisdiction with this chamber, exclusive. Rather, Mr. Speaker, it's not an extension of the Supreme Court. And please don't invite him into temptation and push him on the verge of contact of the Supreme Court. He's a very decent man. He won't listen to you. They shall have exclusive jurisdiction in all matters relating to the enforcement or interpretation of this Constitution. Somebody say we should interpret Article 97. The forum for interpretation in terms of Article 130 of the Constitution is not here. It's in the Supreme Court. And this House is not an extension of the Supreme Court, I'm afraid. Yeah. 132, where an issue that relates to a matter of or question referred to in clause 1 of this article arises in proceedings in court other than the Supreme Court, the court shall stay proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court by parity of reason. Rather, Mr. Speaker, the worst thing you can do to avoid this temptation to make a referral, and even you have been joined, so even there's no need for a referral. They've brought you in already. You see, at the instance of the majority leader, you are supposed to hire lawyers and file processes regarding the interpretation of Article 97. So why are they saying and then make a referral to a committee for the committee to look at it? Some of them are very happy, afraid of the elections that pronounce majority on their side. Please, with the greatest of respect, Honorable Speaker, I know your gravitas and stature and your pedigree. You wouldn't do that. And those of them who are anxious to have majority here, it is the polls, not here. And I don't want to say more than that, because the gentleman who wanted this achieved is my good friend. And the lecturer in law, my dear brother, the lecturer in law, what's his name? Aini, you are saying that there is no factual basis for majority leader to go to court. That's what we are saying. And therefore, you cannot pray in aid Article 2 of the Constitution. So where is the factual basis in law for the Speaker to do what you want him to do? Who would look at the facts? The Supreme Court. So if you want the Speaker to give a decision in a vacuum, and I heard somebody say, when the Speaker is informed. The Speaker is informed about what? What has happened? What is the information about? It is the pleasure of somebody. The information is anemic and hollow. There's no factual basis that people have crossed carpet. and say that the speaker should just rubber stamp under order 18 as is being urged upon you. What is the evidential support for the speaker to take that decision on the mere say so of a political platform, Choboy thinking, trying to appease those he was hearing, and they say, oh, I'm going to use the speaker. Oh my God and King, deliver us, deliver this. I am leaving this chamber. This is a very hollow chamber. We shouldn't taint it with vile propaganda and empty rhetoric. And I'm very, very glad. I'm going to exit this chamber, God willing, with the speaker. We should keep our name and hallow our name. Right now, speaker, hallowed be your name. I'm finished.
This is Joy 99.7 FM, currently happening live proceedings, that debate from Parliament where the Speaker is set to decide on whether or not 4 seats will be made vacant as pushed by that motion pushed today by the former Minority Leader Haruna Idrisu. We're bringing you live updates from Parliament. I'll take you back shortly. Also to come here on Newsnight, parents of 16-year-old suspect driver Bishop Elisha Salifu Amwako and Moha Amwako currently in police custody assisting the investigation into last Saturday's accidents that led to the burning of 2 children at East Legon. We'll bring you more of that also much later. Minority in Parliament makes a strong push for Speaker of Parliament to hold the Ministers of National Security, Interior, Lands and Natural Resources before the House as it demands the Environment Minister accounts for how much has been spent on the galamsey fight. We have another member, that's the Vice Chairman of the Constitutional and Legal Affairs Committee, Bernard Ahiafo, on his feet. I'll take you back to Parliament.
Mr. Speaker, we are governed by rules, and our rules are premised on the Constitution of the Republic of Ghana. Mr. Speaker, the petition being referred to by the Majority Leader is not before the House. What is before the House is the statement. So I do not know why they are speaking about petition which is not before the House. We should restrict ourselves and comment on the statement before the House. Mr. Speaker, our standing order 18 is under the marginal notes, vacancy other than resignation, and it was based on Article 97(1)(b) to E and G and H of the Constitution. And with your permission, if I may read, the Speaker shall inform the House of the occurrence of a vacancy of the seat of a member under clause 1B to E, G and H of Article 97 of the Constitution of the Republic of Ghana. Mr. Speaker, it is important for us to look at what Article 97, G and H is saying in relation to the statement made by the Minority Leader. Mr. Speaker, it says, a member of Parliament shall vacate his seat in Parliament, G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seek to remain in Parliament as an independent member. Then H, if he was elected a member of Parliament as an independent candidate and joins a political party. Mr. Speaker, the statement made by the Minority Leader is simply saying that the Honorable Member of Fomena, Honorable Andrews Amwako Esiama, was elected as an independent candidate, but he has filed to contest on the ticket of a political party. If you are here as an independent candidate and you have filed to contest as an independent, to contest on the ticket of a political party. Let's look at what the provision is saying in 97H. A member of parliament shall vacate his seat in parliament if he was elected a member of parliament as an independent candidate and join a political party. If you are not a member of a political party or you do not join a political party, how can you contest on the ticket of that particular party? So the issue at hand is whether or not Andrews Amuako Esiama, Honorable, having been elected to this house as an independent candidate, now filing to contest on the ticket of a political party, he has moved to join a political party. And if so, what is the Constitution saying? The Constitution is saying that that member shall vacate his seat. Mr. Speaker, it is mandatory, it is automatic that such a member must vacate his seat. And there is nothing wrong if the minority leader in his statement is drawing the attention of the Speaker to that particular fact, so that the Speaker can come under our standing order 18 and inform the House about the vacancy of that seat. Mr. Speaker, he is again saying that Honorable Cynthia Mamle Morrison, Honorable Member for Agona West, Honorable Kojo Asante, the Honorable Member for Sohum, and then Honorable Pitaya Okwachi Aka, the Member of Parliament for Amenfi Central, were elected as members of this Parliament on political party ticket. Now, whilst in Parliament on the ticket of those parties, they have decided to go and contest as an independent candidate. And what is the Constitution saying? The Constitution is saying in Article 97G that a member of Parliament shall vacate his seat in Parliament if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seek to remain in Parliament as an independent candidate. So in the circumstances, Mr. Speaker, the statement is just drawing your attention to the acts of these members of Parliament, which will mean that their seat is automatically vacant. Mr. Speaker, I have listened to an argument that they have not crossed carpet or they are still members of that particular party. Mr. Speaker, they are making that particular statement without reference to their own political party constitution. And Mr. Speaker, with permission, I would want to read Article 3(9) of the NPP constitution, their own constitution. And it's rather unfortunate that senior members of the party are arguing that a member of their party elected on the ticket of their party, now contesting today as an independent candidate, still remains member of their party. At least, let's be honest and uphold our various party constitutions. Mr. Speaker, it's under the marginal note forfeiture of membership. Article 3(9) of the NPP constitution is under a marginal note forfeiture of membership. And Mr. Speaker, it reads, a member of the party who stands as independent candidate against the officially elected member of the party, or who joins or declares his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general or a by-election, automatically forfeits his or her membership of the party. Mr. Speaker,
Members are no longer asked to speak.
if this is what their own constitution is saying, how can you come to a house of record to argue that members of your party elected to parliament on your political party ticket now contesting on the tickets as independent candidates still remains members of your party? What interpretation are you putting on Article 3(9) of your own constitution?
Not being members of your party, how can they remain?
If the person is not members of your party, by mere fact that they are contesting as an independent candidate, how can they remain members of your party? And to say that it is only when you cross carpet that a vacancy can be created, when you cross carpet in the chamber, that one, it cannot be a correct statement. We are lawyers, so let's look at the law and then apply the law to the facts. The fact remains that they are members of some political party. Peter Yaokwachiaka is a member of the NDC, now contesting as an independent candidate. He can no longer be a member of our party, and by our own party constitution, Cynthia Mamle Morrison is contesting as an independent candidate. She cannot be a member of your party. Asante Kojo, member of parliament for Sohun, was elected on your party ticket. He is now contesting as an independent candidate. How can he still be a member of your party? So, Mr. Speaker, if you look at the constitution, it's very clear that by the activities of the members mentioned, the seat is vacant. And all that the Speaker needs to do is to come under Standing Order 18 and announce the vacancy. That is all that we are asking Speaker to do. They have spoken extensively on the court action. You see, in the case of Bernard Ahiafo versus the Speaker of Parliament and Attorney General, Bernard Ahiafo and others versus the Speaker of Parliament and Attorney General, this is what the Supreme Court says. Unless Parliament has taken a decision which you feel that decision of Parliament infringes on the Constitution of the Republic of Ghana, they don't have any jurisdiction. Therefore, they won't grant even an injunction. So, they will not intervene in the processes of Parliament. And that should be a guide to my brother in instituting a similar action. Why? Parliament must be allowed to work. We all took an oath to uphold and defend the Constitution of the Republic of Ghana. Parliament has a responsibility. The law is clear that when A, B, C, D happen, the seat must be declared vacant. So all that we are saying is that the seat must be declared vacant. This has nothing to do with the December 7 election that we are going to do. As for the December 7, we will form the overwhelming majority by beating you. Mr. Speaker, I thank you very much for giving me the opportunity.
Honorable Ajapa Mesa, am I right?
Right, Honorable Speaker, it's Ijapa Mesa. Speaker, thank you.
Yes. Yours is spelled with E, right?
Yes, it is.
Ijapa, yes.
Ijapa.
Yes.
Good Father. Speaker, thank you for the opportunity to contribute to the statement that was made by the minority leader. Mr. Speaker, indeed, I was driving into the chamber when Joy FM's headline news of 5:30, I believe it's called the news, I've forgotten the name, started airing. And listening to the arguments being made by learned counsel who I expect to be much more candid and uphold the principles that we all studied in law school, I felt rather sad. Mr. Speaker, why do I say this? The principle clearly is that in construing legislation and indeed the Constitution of the Republic and any law for that matter, you ought to put a purposive interpretation to that construction. And so when I hear my friends on the other side argue that Article 97G is applicable in this case, I feel sad. It's as if to say time and the tenure of Parliament is irrelevant in the discourse. And it certainly cannot be. Because the mischief that this provision seeks to cure is clear. It is within the course of the term of that Parliament. So how you construe intentions in the future and say that should be applicable today is baffling. Mr. Speaker, with respect, Honorable Atachia, listening to him, said a lot. And I will urge the House to be guided by the wisdom in his articulation. This is a House of record. This is a hallowed chamber of Parliament. And it's important that we shed our political clothes when we are dealing with matters of this nature. Because posterity is going to judge us. Mr. Speaker, when the previous rulings of the Speaker become binding on the sitting Speaker, indeed, it is not even persuasive. So, how is it the case that people can rely on the ruling of Right Honorable Mike Okwe as basis to make this argument today? Please, it's important that we seek to do what is right at all times. I recall, Mr. Speaker, that people on the other side of the House, when Right Honorable Mike Okwe made those rulings, objected. They supported Honorable Andrew Esiama. So what has changed? How is it the case that they supported Honorable Andrew Esiama and disagreed with the ruling of the Speaker then, and now turn around and make it look as if the ruling today that they are seeking for is right? In any event, Mr. Speaker, with respect, this is a statement that has been made under Order 93 of our standing orders. Is it a suggestion then, therefore, that you are to set up a committee to investigate the matter, or merely people making comments or members making comments should suffice for information? Oh, so is that the exercise, the reason for which we are engaging in this lengthy debate? So, Speaker, with respect, my good friend Honorable Ahiafo makes the point that the NPP constitution, he conveniently omits to interpret the entirety of the NPP constitution as a whole. He forgets or conveniently excludes the rights that members have under the NPP constitution. As we can permit me, Article 4 and 3 of the NPP constitution is clear. that even if members are deemed to have vacated their position as members of the party, they still have a right to be heard. So that reference in itself is inapplicable because it cannot be automatic. So, Speaker, I will urge of you not to fall in the temptation as Honorable Atachia invited you to, that the minority is setting for you today. You need to stand up and be counted. That when it mattered most, Mr. Speaker did not pander to the whims of the minority to make any determination that would be adverse to the interest of the constituents that these members of parliament represent. Mr. Speaker, their intent is futuristic. They have not cross-carpet as the Honorable Wayo Seni did during the time that he was in the Parliament of the Republic of Ghana. I believe it was during the 4th or 5th Parliament, when he stood up in his place and made a declaration that he has ceased to be a member of the NDC and is moving to be a member of the NPP and cross-carpet to join the NPP. None of these members have exercised or done any such act for you to be called upon to make a declaration that their seats are vacant. So, Speaker, the facts are clear. These members have not vacated their seats. The NPP has not removed them as members of the New Patriotic Party. They have not petitioned. Nothing that should be urged on you and this House to remove or declare their seats as vacant under Article 97. And I urge you to disregard the invitation and let us move on to deal with important matters of state. I thank you for your time. Thank you.
Honorable Dafiamapo.
That is the law.
Speaker, I am very grateful for the opportunity to comment on the statement ably made by the Honorable Minority Leader, bringing this very important matter to your attention. Mr. Speaker, I can sympathize with the Majority Leader and his battalion that you come to work in the morning as Majority Leader and by close of business, you are living for the House as Minority Leader. Mr. Speaker, we are urging on you to apply the decision ably delivered by Professor Michael Kui on the 43rd day of Saturday, November 7th, that it is of similar effect and applicable mutatis mutandis in this matter. Mr. Speaker, the constitutional language of joined as used in Article 97, 1G and H. What are the incidents of joint? Mr. Speaker, let me reference the House to Constitutional Instrument CI 127 regulation, Mr. Speaker, particularly Regulation 14. Mr. Speaker, Regulation 14 is in respect of allocation of symbols and colors when candidates file before the Electoral Commission to contest in an election. The processes that happen under Regulation 14, Mr. Speaker, is that the Electoral Commission, upon the closure for filing of nomination, allocate symbols and colors, so that under Regulation 14.1 of CI 127, where a candidate is sponsored by a political party, that candidate is allocated the political colors of the party that sponsors him or her. Mr. Speaker, under Regulation 15 of CI 127, the candidates, Mr. Speaker, are published in what we call the notice of poll. And Mr. Speaker, the notice of poll, the Electoral Commission is constitutionally mandated to gazette it. And in publishing the notice of poll, the candidates as they file are indicated on the notice of poll regarding your position if you're on the ballot paper. Mr. Speaker, the facts as being narrated points to the fact that the 4 members of parliament, one, the Honorable Andrews Amwakwe-Siama, who also happens to be the 2nd deputy speaker of this house, serves in this house as an independent member of parliament. Mr. Speaker, you had cause to pronounce on his decision to caucus with the majority. To caucus with the majority is to do business with them. It doesn't constitute joining as a member. Mr. Speaker, if mere caucusing with them was sufficient, why has he taken the definitive step now to file on the ticket of the MPP and to be sponsored by the MPP? Because that constitutes joining properly so-called under law. Mr. Speaker, there's operation of automaticity of law. And when we are reading the Constitution, Mr. Speaker, we are enjoined to interpret the Constitution as a whole, and we also read it as a whole. In reading the entire Article 97 as a whole, Mr. Speaker, these are the incidences that the framers point to. Article 97(1) says, a member of parliament shall vacate his seat in parliament. A, when upon the dissolution of parliament. Mr. Speaker, when there's a dissolution of parliament, you don't have to go to the Supreme Court for an interpretation. It is automatic. You cease to be a member because the incident, the action of dissolution of parliament has occurred. So there's no need to call in the Supreme Court to interpret anything. B, if he is elected as Speaker of Parliament, Mr. Speaker, when Speaker Joe Ajahu as a member for Akachi South got elected as a member, by operation of law, he ceased to be a member of the House. And the Honorable Ayanfo, who is before us here today, got the opportunity to be elected to replace him, as it were. That is operation of law. There was no need for anybody to go to the Supreme Court to seek an interpretation as to whether or not upon the election of Honorable Dua Ajahu as a member of Parliament as Speaker of the House, whether he had to vacate his seat. That is automaticity of law. Mr. Speaker, D, if the member is expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, Mr. Speaker, when that happens, it is automatic. You leave. There's no need for a Supreme Court to come in. Mr. Speaker, if we go to E, having abandoned E. F, if he resigns from office as a member of Parliament by writing under his hand addressed to the Speaker. Mr. Speaker, when this happens, this House cannot be debating this matter. That a member has resigned under his signature, and whether or not by resignation there's a vacancy in respect of his seat. It is automatic. Mr. Speaker, so it is automatic that under 97(1)(g), if he leaves the party of which he was a member at the time of his election in Parliament to join another party. Mr. Speaker, we are saying that these members have joined another party or have departed from the party that sponsored them and brought them to Parliament. Mr. Speaker, in making all these arguments, let me read in extenso the rendition by the Honorable Professor Michael Kwe on the very fateful day of November 7th, 2020. Mr. Speaker, I hear this to say, honorable members, before our visitors come in, there's a ruling I have made on the petition for the declaration of the Formina seat in Parliament as vacant. Parliament is in receipt of a petition from the General Secretary of the New Patriotic Party, MPP, inviting the Speaker of Parliament to declare the Formina seat in Parliament vacant. Mr. Speaker, the Member of Parliament, Honorable Andrew Amakwesiama, who has been written to, has responded accordingly, and copies are attached to the ruling. The NPP invoked Article 97(1)(g) of the Constitution of the Republic of Ghana 1992, which provides that a Member of Parliament shall vacate his seat in Parliament if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. The Constitution of the NPP, which the MP freely subscribed, provides in Article 3, Clause 9, Paragraph 1, that a member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or defects his or her support for another political party or for an independent candidate, when the party has sponsored a candidate in a general by-election, automatically forfeits his or her membership of the party. The moment the MP filed his candidature with the Office of the Electoral Commission to contest the next election as an independent candidate, it shows clearly that he seeks to leave his party. This automatically triggers forfeiture of his party membership. He cannot have the desire. Mr. Speaker, I believe that we need to listen to your predecessor here. He cannot have the desire to leave, take a step towards it by filing as an independent candidate, and yet claim to be a member of the party. The step taken to contest against his party automatically triggers forfeiture of membership. Having forfeited his membership of the party on which ticket he was elected to Parliament, the operative language of the Constitution is that he shall, which is mandatory, vacate his seat in Parliament. Going by a purposive interpretation of the present law, constructive action on the part of the MP is important. With all intents and purposes, he is no longer a member of the party. He has pronounced himself publicly as an independent candidate and has filed papers to compete against the party and its official candidates as an independent candidate on 7th December 2020. On that occasion, this current parliament will still be sitting and operating as an official parliament of the Republic of Ghana. We shall not have a situation adopted freely by any city MP where he or she would be campaigning openly against the party that he or she still represents in Parliament, and yet ridiculously stands against the party. No purposive interpretation of law will allow such a ridicule to prevail. Mr. Speaker, furthermore, after 7th December 2020, when Parliament is still in session till 7th January 2021, how does an MP operate both as an elected independent MP and at the same time an MPP member if he should win the election? This lacuna of a ridiculous situation is not what is anticipated under the 1992 Constitution. In the circumstances, it is determined that the conduct of Honorable Andrew Amakwesiama amounts to vacating his seat in Parliament. Accordingly, we bring this to the notice of the Electoral Commission for the necessary action to be taken in accordance with the law. Signed, the Right Honorable Speaker. Mr. Speaker, the gravamen of this argument is eruditely captured by the ruling of Professor Michael Quay. Mr. Speaker, to conclude, we are saying that the matters as envisaged by the Constitution in Article 97 are clearly given birth by the conduct of our four colleagues. And Mr. Speaker, we are only urging upon you to enforce the decision ably given by Professor Michael Quay on 7th November 2020. Mr. Speaker, which decision has remained unchallenged and remained good law and has guided this House ever since. So, Mr. Speaker, I will want to pray you that the need to elect another deputy speaker, which must come from NDC side because of Article 93 of the Constitution, is rife. And I believe that awareness, that reality is what has shocked the conscience of our brothers. And they must know that the Constitution, the enforcement of the Constitution, is our above duties that we must uphold. Mr. Speaker, with these words, I thank you for the opportunity.
This is Joy 99.7 FM, and of course we're bringing you live proceedings from Parliament on that petition to declare seats vacant. The MPs are debating the minority's move to oust 4 MPs from Parliament. They've been giving a justification. We know that the majority leader has been to the Supreme Court to stay Parliament on taking that particular decision. But as we speak, the debate is currently underway, and the Speaker is presiding over that. Of course, you've been hearing from the minority. In fact, their push now is for a second deputy speaker to be elected because he's one of the MPs affected by this particular move that they are seeking the speaker to rule on, citing a previous decision taken by Professor Michael Quay. Let me take you live back to Parliament as another speaker, another MP is on his feet on this particular issue, and that's the chairman of the Constitutional, Legal and Parliamentary Affairs, Kwame Enyimadu-Entry.
Mr. Speaker, looking at the procedure under which the application had been made before you, I was tempted to believe that this exercise, apart from comments, is much ado about nothing. The Article 93, under which the applicant had made this application, Order 93, Mr. Speaker, and other speakers had said it, that 93(6) says, where a member makes a statement, the Speaker, considering the comments on the statement, may direct a committee to investigate and inquire into the matters and where necessary, propose legislation. Mr. Speaker, I think the effect of this is to enrich our laws. The provisions under Article 97 were put into the Constitution historically because of what have happened in the nation. Mr. Speaker, in the First Republic, people were just literally living from one political party to the other. And Mr. Speaker, you are a veteran in this House, and I would want to remind you of Wayoseni, who physically crossed carpet to the other side of the aisle. Mr. Speaker, that was the purpose of such a provision, that people must not cross carpet during the session of the Parliament. We are in the 8th Parliament, and we are preparing to go for the 9th Parliament. The intention, therefore, is that whilst we are in the 8th Parliament, you cannot cross carpet to the other side of the aisle. Mr. Speaker, this is what the Constitution is preventing. Now, my colleague had read the ruling of the then Speaker in greater detail, and I think that with a greater respect to the learned professor, Mr. Speaker, I think that if we are listening to him very well, and I don't want to bore you to read through, most of the things are contradictory in the ruling. Mr. Speaker, a portion that my colleague read reads, the constitution of the NPP, which the MP freely subscribes to, provides in Article 931 that a member of a party who stands as an independent candidate against the officially elected member of the party, or who joins or defers his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general or by election, automatically forfeits his or her membership of the party. Mr. Speaker, let us not forget that the NPP as a party petitioned the Speaker of Parliament then that Honorable Andrew Amakwasiama had been removed as from the party because he had crossed carpet to the other side. And the MPP referred to its constitution, and this is what Speaker Mike Okwe was referring to, not any other constitution. Mr. Speaker, the learned former Speaker referred us to Article 55.5, and with your permission, I may want to read. 55.5 says that the internal organization of a political party shall conform to democratic principles. Sorry, at 55.6. An organization shall operate as a political party unless it is registered as such under the law for... No, that's not what I want you. Every political party shall have a national character, and a membership shall not be based on ethnic, religious, regional, or other sectional divisions. And it goes on to say that political parties, with the political parties would organize its own internal affairs with love. And that is what Professor Mike Okwe was referring to. In the Hansard, Mr. Speaker, it was referring to the new Patriotic Party Constitution. And the new Patriotic Party Constitution, which they petitioned the Speaker that the gentleman, that is Andrew Asiama, had violated the MPP Constitution. And the MPP removed him as a member of the party and went ahead to tell the Speaker that they had removed him. Mr. Speaker, what we have and the processes and the procedure that had been used is a comment by a member of Parliament, not petitioning the Speaker, not petitioning Parliament, just saying that he thinks that a member had filed. Mr. Speaker, we are in the 8th Parliament, and everything that any person plans to do.
Yeah, Honorable Chairman, I think in trying to quote the Constitution vis-a-vis that of the NPP party Constitution, you seem to have maybe slipped and not gotten the article rightly. So you didn't get enough time to go back to read it. I think that is what has ignited Honorable Bernard Ahiafo to be on her feet. So I'll give him the chance to draw attention to what it is. Please, Honorable.
Mr. Speaker, thank you for the opportunity. Mr. Speaker, the ruling of Right Honorable Professor Michael Kojo is very clear. It's stating that based on Article 391 of the Constitution of the NPP, the member who has decided to contest as an independent candidate cease automatically to be a member of the NPP. It is for that reason, that's why the Secretary, the General Secretary, is invoking Article 97(1) of the Constitution of the Republic of Ghana to declare the position vacant. So you need to come clearly about what the ruling of Right Honorable Makokwe is saying.
No, but the issue the chair was drawing attention to is that the statement was contradictory. And he was trying to read Article 55(5), which deals with the democratic procedures of each political party in handling such matters, which, according to him, was not adhered to by the NPP. So he was trying to say that those provisions were contradictory. The position taken by the former speaker vis-a-vis their provision in the party constitution and that of the constitution. But he didn't get it right. So I really understand why you are raising your point of order, but please let's allow him to continue.
Thank you, Mr. Speaker. Mr. Speaker, the distinction I want to draw here is that no political party had petitioned this House, and no political party had removed any person from his membership, and nobody had complained before this House. What we have this afternoon before us is a comment that a member of parliament, a statement that a member of parliament had made. And
well, that's Kwame Enyumeduentri there, the chairman of the Constitutional and Legal Affairs Committee of Parliament there, making his point forcefully as well. Parliamentary Affairs correspondent Kweku Asante joins us on the line. Let's get an understanding of what exactly will happen today. Are we going to get the speaker to actually decide on this matter today, or what else will happen? Kweku, what do we know?
Well, so it's been a spirited debate from both the NDC and NDP. This has turned into a political footballing game. Both of them have been really making their point forcefully, for which reason they believe the seats must be declared vacant or not. We do not expect that the speaker will make the ruling. In fact, when the commenting and the debate started, the speaker did make a point that he really believes that this is an issue he will have to take some time and study and then present a written ruling of a sort. And so that is the position we are getting from the speaker, that he probably will ask that this matter be put on ice. He will later come formally by way of a communication in terms of his full ruling and reason for which reason he believes either the seats must be declared vacant or not. And so the debate is going to conclude pretty shortly, but we expect that the Speaker of Parliament is not going to make a ruling, at least not today, given his earlier indication that this is a very weighty matter that he, as he usually says, he would want to go and consult the old lady.
Well, that's a Parliamentary Affairs correspondent, Kweku Asante, there monitoring events for us as that debate ensues in Parliament on whether the 4 seats should be declared vacant, including the second Deputy Speaker's Fomina seat. And we're following events closely for you. But in wrapping up, also, parents of 16-year-old suspect driver Bishop Elisha Salifo Amwako and Moha Amwako currently are in police custody, assisting the investigation into last Saturday's accident that led to the burning of 2 children at East Legon. Well, the police in the last few minutes has issued a more detailed statement on actions taken so far and state of survivors and the suspect. The police starts by talking about the fact that they've arrested the suspect, Bishop Elisha Salifo Amwako and Moha Amwako, parents of the suspect driver involved in the fatal accident that claimed 2 lives at East Legon. Investigations, they say, have so far established that on 12 October 2024, the suspect driver, age 16, driving a Jaguar SUV vehicle with registration number G8780120 with 1 other occupant rammed into a 4x4 Acura vehicle, also with registration number GR254223, driven by Joseph Aka with 4 other occupants at Mensawood Street at East Legon. Both cars caught fire and burned beyond recognition. The investigation further indicates that 3 of the 5 victims in the Acura vehicle during the accident were rescued and the other 2 identified as Justine Agbenu and Mame Jumo, both 12 years of age, lost their lives, while 2 of the rescued victims who sustained minor injuries were treated and discharged, while the third is still on admission receiving medical attention. The suspect driver with other occupants in the Jaguar vehicle were also rescued and are currently on admission at the hospital. The statement goes on to say that the parents of the 16-year-old suspect driver, Bishop Elisha Salifo Amwako and Moha Amwako, are currently in custody, assisting with investigations. Meanwhile, a team from the Police Management Board, led by the Inspector General of Police, Dr. George Akufu-Dampare, today visited the bereaved family to commiserate with them and also visited the injured at the hospital. The police concludes by saying it would like to assure the public of a thorough investigation into the accident to bring closure to the affected family as they continue to remember them in our prayers in this difficult time. So that's the situation with the East Legon accident over the weekend. Well, taking you back to Parliament earlier, though, the minority there is also making a strong case for the Speaker of Parliament, Alban Bagbin, to hold the Ministers of National Security, Interior, as well as Lands and Natural Resources to provide the House an update on government's efforts to fight illegal mining. Government in the past few days has deployed security forces to some mining areas in its renewed fight against galamsey. We've been hearing from the former minority leader, Haruna Idrisu, who's been pushing for the Environment Minister to account for how much has been spent on government's fight against illegal mining so far.
Every Ghanaian knows that we are failing. Mr. Speaker, it will be my request that you take up this matter much more seriously and invite the 3 ministers of state, the Minister for Lands, Natural Resources, the Minister for National Security, the Minister for Interior, and all other institutions involved and the Minister for Environment, Mr. Speaker, to publicly account to Ghanaians through you how much have so far been spent in the name of fighting illegal mining and galamsey, and how much destruction in terms of official report to our water bodies. And Mr. Speaker, you can give consequential direction. The people of Ghana expect that of us as Parliament, that we hold persons in whom we have entrusted the supervision of our natural resources accountable. And Mr. Speaker, the Constitution vests our natural resources in the hands of the President. So, Mr. Speaker, that would be my first take.
Well, in a strong response to the claims by the Majority Leader Alexander Afenyo-Markin accused the Minority Leader of seeking to politicize the fight against galamsey.
Mr. Speaker, we cannot, as a political class, blame game on galamsey and say that a particular political party, in this case, the Akufo-Addo administration, has failed in its fight against galamsey, and leave out what happened preceding the administration of Akufo-Addo administration. Indeed, it's a known fact that Akufo-Addo administration took a decision to deploy the Ghana Armed Forces through what is known as Operation Halt in the early years of his presidency, and the aim was to combat the threat of illegal mining, which was wreaking deliberate havoc on the nation's water bodies and forest reserves. Mr. Speaker, it was because at the time he took office, the galamsey activity had gotten out of hand and the then administration had no immediate answer to it. While the operation achieved some successes, various challenges arose that undermined the effort to fully eradicate the menace. Mr. Speaker, as a parliament, it is important for us to acknowledge the President for taking a bold decision to fight the menace of galamsey. Mr. Speaker, the President, in a statement released, has reinforced the operational and tactical capacity of the Operation HALT by directing the Minister of Defense to deploy additional military personnel to intensify the ongoing Operation HALT across the country. For the first time in this fight, logistics such as naval boats are to be deployed on water bodies to stop all legal and illegal mining activities on water bodies across the country.
So that's the Majority Leader, Alexander Afenyo-Markin. And as we speak, the debate is still underway and it's live on the Joy News channel. You want to catch all the action about this particular debate on whether or not the 4 seats must be declared vacant some 53 days to election 2024. We'll wrap up with National Science and Maths Quiz. Three-time winners of the National Science and Maths Quiz, St. Peter's SHS is fighting to reclaim their stand amongst the giant once again. Knocked out at the preliminary stage last year, the once invincible team is facing Sirugu Integrated and Hohwe EPSHS in a contest that could see them start their comeback tour or slip further from their former glory. Meanwhile, the fresh faces of this year's NSMQ, Kofi J SHS and Our Lady of Grace SHS, both from the Ashanti region, are breezing their way to the 1-8 stage in grand style.
Contest, which is Kofi AJ Senior High School. They ended this contest with an incredible 42 marks.
You know, this is actually our very first time of being in the national competition. And then, as you can see on my face, she's very excited to be here. We don't have to talk much about this thing. We are going to prepare them for the next stage competition. Once we heard the name of the school we are competing with, the Kade and the Damango, we knew that it's a done deal for us.
How does this make you feel?
Yeah, this is not something new. We did it during the regional qualifiers. We got to the semi-finals, though it was our first time, and we knew that this time we're here to conquer, to get to higher heights.
And St. Peter's has definitely won that game already. It's 65 points, Hohwe EP 44 points, and Sinurugu Integrated SHS with 7 points. The Giants are back in the race. And that's how we wrap up today's edition of Newsnight, rather abridged version, because we're bringing you a live coverage from Parliament. After the sport of commercial break, we'll bring you the Geek Squad. Please do stay.